Hi, my name's Charlie Sauer. I'm the president of Entrepreneurs for Growth, and we provide entrepreneurship education here on Capitol Hill. In fact, we have a series that we're teaching right now in the Senate that both the Democratic Steering and Outreach Committee and the Republican Steering Committee helped us put together. And in that series, we're teaching entrepreneurs how to take an idea and turn it into a company, then how to add fuel to the hot rod and actually get funding, and then in the end, how to exit. So at each of those three places, intellectual property is important to the business owner and the investor and then eventually the buyer. And so that's why we have our three experts here today is to talk about intellectual property, and that's importance during the three stages. And so we have Valerie Gatos. She's the founder and president of Capital Growth, Inc. She's also the founder of the Angel Venture Forum, which is a year-long program where she works with entrepreneurs and their companies. And if you've ever seen the Shark Tank, at the end, the entrepreneurs actually pitch angel investors in the room. And Valerie's Angel Venture Forum has about a 70% success rate on finding those entrepreneurs funding. Up next, we have Doug Humphrey. He's a serial entrepreneur, lots of big wins, several big losses as well. You aren't really an experienced entrepreneur until you have a couple of big losses. His claim to fame is that he was the father of managed hosting. It's a company called Digex that IPO'd. I'll let him tell you about his big losses if he wants to. But he's here today because he holds several patents himself, and he's also in a current startup that has IP. And then we have Mark Schultz. He's a senior scholar and co-director of the Center for Protection of Intellectual Property. He serves as an associate professor of law and director of faculty development at Southern Illinois University. And he was honored by SIU School of Law as its outstanding scholar in 2008. He has served as chair of the Federalist Society's Intellectual Property Practice Group. He's chair of AALS section on Internet and Computer Law. And as an NGO delegate to the World Intellectual Property Organization, he currently serves as a consultant on trade secrecy to the OECD and is chairman of the Academic Advisory Board of the Copyright Alliance. So without further ado, let me get out of the way and let Valerie start.
Hello, thanks so much for being here. I really appreciate it. So I'm going to try to keep this short because I do want to leave a lot of time for questions. But a little bit about my background is that I had actually started into the angel world, angel investing, and investing in small business because I was a successful entrepreneur. And so I was my own first investment, and it actually turned out pretty well. So in many respects, angel investors who look at investing in small companies, we do look for success stories and formulas and what is going to be success. But the number one thing is that angel investors and investors in the level that we invest, we are not philanthropists. Now, we may do philanthropy, but what we do when we invest in companies is that we look to make money. And we hope that you guys make money as well. And that's I think the number one thing that people misunderstand when they're talking about angel investing. So what do I look for as an angel investor? When I invest in companies, now I'm a small angel investor and I invest with multiple different other angel investors. We pool money together and raise up to about $1 million for a company at any one time. And the small amounts that go in from per investor can range from $50,000 to $100,000. And then if the company's going well, second and third rounds, which can get the company up to $1 million. So that's just a quick summary of the level in which I invest, which is not huge, but it's seeding many companies because number one, technology has gotten so great that it is easier to start a company more than ever. So what do we look for as an investor? I look for about 2 or 3 different things. Number one is management, the quality of the management team. Number 2, I look for scalability. That means that you build it once and you could build it multiple times, and each successive time you build whatever that unit is, it's going to cost less and less and less. Pharmaceuticals, technology, other things like that tend to have the greatest scalability, unlike service businesses, which means the more you expand, the more then you've got to hire more people. So we want that equation to go reverse. The more you build your technology, the less people we need. So at the end of the day, what makes that happen? Technology, patents, patents, patents. So when we invest, what do we look for? We look for patents. Something that I can actually physically take on a piece of paper and understand and say that when I'm investing in that company and there's a garage sale, that's what I walk away with, and that's what I sell to Apple, Intel, et cetera. So it's the intellectual property that is most important for us. So as an investor, when you're looking at what the environment is for technology, number one thing is what do I have on a piece of paper that says that this is something that's unique? So, and I guess, is there anything else you want me to cover at this point?
No, let's
Yeah, I'm going to keep it short and then leave it all for questions. Doug?
Not a lot of notes. It says Valerie spoke. That's it. Actually, though, your point on IP survives death. I like that. That's one of my notes here. My name is Doug Humphrey, and I feel like I'm at an AA meeting here. Hi, I'm Doug. I'm serial entrepreneur. Everybody's hi, Doug. Sometimes, we do need a little help every once in a while. We serial entrepreneurs. I start companies. It's what I do. I start them. A lot of people think, go start a company. And it's sort of like saying, go invent something brilliant today. You can't do that just like that, just on spec. I'm important. I'm the jockey that rides the horse, but the idea is the horse, and the idea is more important than the jockey. Although there are investors who will tell you that a really good jockey can make an okay horse run pretty well, and a horrible jockey can ruin the best horse. So there is sort of a precedence there. Intellectual property, important for what I do. I start the companies that Valerie, for example, might invest in. Seed level in the beginning. I have a company right now that's at seed level. It's raised about $200,000. There are 5 of us working on it. Obviously, nobody's getting paid much. It's okay. It's what happens in startups. And we're building intellectual property to the point where it's important enough that we're holding off an alpha release of our product because the intellectual property, the PPAs, which are preliminary patent applications, things that you can put in up to a year before you, say, do your real patent application, because we don't have the money to crank through the real patent applications, another sore point with the world. But we are not going to be able to file our PPAs probably till the 15th of this month, which means we will hold off introducing the alpha product until after the PPAs get filed. Not that we need to per se, if you read the law carefully, but the law is in flux right now, and so we want to be absolutely sure that if we ever run into a situation where somebody actually says, but you revealed this to the public before you filed your PPAs, I want to be able to say absolutely nope, 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 nope. Boom. You can see the filing dates and you can see the start dates for the demo. Intellectual property is important at all phases. I mean, right now we're a startup and we're doing our PPAs. So that is a way to try to get your intellectual property registered up and get it in flow in the system before you can afford the outrageous 10 to 20 grand a patent application at least that you have to come up with to actually file. I think that there was a travesty that the IP, what was the name of the last IP thing that went through? America Invents Act, yeah. Okay, does everyone here support me in saying that if one side introduces a bill, the other side should get to name it? See, I think a lot more truth would get committed that way, right? Because right now, it's whoever actually puts the bill out gets to actually put their beautiful advertising moniker on it. And I'm kind of like, great, that doesn't tell me anything. Why would I believe that? So anyway, yeah, the American Invents Act basically managed to say, oh, it's not the guy who first invents. It's the guy who first files, which means it's the guy who first invents plus his $20,000. Okay, so.
That would be my $20,000.
Yeah, that would be your $20,000. That's right. Hey, Val. So terrible, terrible law. But anyway. So it's important for us, though. It's important at all stages. It's important at the very, very beginning that we know about this, because what you're really doing is documenting the things that make you different and the things that are going to allow you to have some intellectual property purchase and fight back when everyone else in the world decides to copy you. And in the middle, when you're actually getting these things built, it's important because it solidifies, codifies your intellectual property and gets it into a point where if somebody comes up to you and says either what do you do, or why can't I sue you, or why can't you sue me, or why don't I invest in you, or any of these questions, you can look at them and say, here are the patents, go check it out, get back to me. You can just put it in their court and say, here it is, fully documented, all set up, don't waste my time with it, it's right there. And then if you have any questions, let me know. As opposed to having to start the long song and dance on exactly what your advantages are. And then in the end, if your company succeeds, people will try to copy you. So you have defense against those things that are unique. If your company succeeds, companies will want to buy you. And one of the first things they'll say is, well, what am I really buying? And you can show them an intellectual property portfolio and say, well, here it is. And if your company fails, the investors are backstopped because the investors, it's nowhere near always worth the money or anything. Usually you can just wallpaper your bathrooms with these things and that's fine. But they'll actually be able to get their intellectual property in form of issued patents and stuff and have an opportunity to recoup their losses. So that's about it. So I'll, you guys deal with the door and let's keep moving.
As the academic, I've been asked to, I think, provide a broader perspective and comment a bit on the many bills that are currently pending to commit further reforms on the patent system. The first reaction I have to these bills generally, and these bills include a variety of proposals, some of them with some merit, some of them of quite dubious merit, to do a variety of things like fee shifting and joinder reform, things grouped under the rubric of litigation reform. My general reaction to these bills is cut it out. Seriously, it's time to take a pause. The great economist Milton Friedman once told his friends in government, don't just do something, stand there. And that's of course, I'm speaking in the House here, so of course you have to do something. But there are a lot of other things you can do. If you want to affect and support innovation, you could do visa reform for entrepreneurs. You could make it easier to take a company public, to get financing. There are a lot of things you could do. The problem with continuing to work on the patent system is that we had a massive reform 2 years ago, and we don't know everything, what the full implications are of that reform yet. I teach intellectual property law, and when you teach law students, typically you teach them out of a case book with lots of decided cases. You have a lot to say. We don't have anything in the case books yet on the AIA. My email inbox is filled with continuing legal education programs and programs by the organized bar, patent bar, still trying to figure out what the AIA means. I mean, we know what it means, but still working out the details, working out the implications. There's still a lot of uncertainty. And uncertainty isn't good with respect to property rules. Property rules are supposed to be things that people can depend on, rely on, make really, really big bets and investments based on those rules. And that's why we don't change property rules often. The last time the Patent Act saw that kind of reform was 1952. And that is, that's about right. I think we could have waited longer, but 60 years was plenty of time. But 2 years is not. And here's the problem. Not only are we keeping things unsettled and making investors and inventors and people working in the innovation economy wondering what's next, but we are also sending a signal that the property rules could change from year to year. And that is particularly dangerous to parties who want to make investments, parties who want to know how to value their work, their innovation. We're sending a political signal that, that basically the loudest lobby group, the issue of the day, could change the basic rules of the system. So property rules need stability. That's perhaps the first and most important point. Another issue with these proposals is that many of them appear to be premised on an assumption that asserting patent rights is invalid, somehow problematic. And particularly, there's a concern about so-called patent trolls. I prefer to call them patent licensing companies. But the big concern about, first of all, about asserting one's patent rights, I have to say that litigation, yes, it can be problematic. I was a transactional lawyer in my practicing career. I always thought of litigation as something of a tragedy. But sometimes it's necessary to keep everybody honest. Sometimes you need to assert your rights. And when you make it harder to assert rights, the value of property rights goes down. It's that simple. When it's more complicated, when you're more likely to lose, when the effects of losing are worse, the value of your property goes down. And I want to make a few quick points because I don't want to monopolize the podium, but I thought I'd offer some points of historical context. There's a really interesting paper that recently came out by Naomi Lamoureux and Ken Sokoloff, some economic historians. It's called Patent Alchemy, the Market for Technology in U.S. History. And they make the point that this new furor over so-called patent trolls, over individuals, inventors, and small companies who don't actually practice their patent but attempt to license or sell it, they argue that this is historically a historically blind controversy. Their findings tell us that during most of U.S. history, it was as common for inventors and small companies to license or sell as it was to start their own firms or work as salaried employees. That the ability to find buyers of patents quickly was something that helped finance one of the most inventive periods in U.S. history, the late 19th and early 20th century. These inventors counted on specializing in invention and not in running companies. Inventors, these folks will tell you, the inventors, the first founders, are often not the ones you want running the company. And so they specialized in inventing. And who do we know from that era, most famous of all, who specialized in inventing? Thomas Edison, all right? And Edison, when he got his start, he financed his early career, Lamoureux and Sokoloff find, that by examining Edison's first 25 patents, he assigned at least part or all of the first 20 patents to get enough revenue to start up his operations, to finance his inventive activity. And even after that, Edison specialized in invention. He often was on the board of or owned an interest of the companies he worked with, but many of those companies could now be called patent trolls by today's standards. The point was that we had this period of great inventive activity. Now, a lot of economic historians also point out that something changed in the 20th century. By the mid-20th century, it was an era of big companies. Most inventive activity was occurring in companies like AT&T, IBM, these behemoths, and they didn't transfer or assign their patents, and they didn't litigate them as much. What they did was they cross-licensed. It was kind of a cozy arrangement. These big industrial corporations, big business, cooperating together, not competing, not being disruptive. And by 1970, only 5% of patents worldwide were filed by individual inventors or small companies. What Lamoureux and Sokoloff point out is that by the late 20th century, we had seen a renaissance in individual invention, of small companies inventing. So from 1970 to 1990, that number went from 5% to 1/3, and it's exploded since then. And with that, we've also seen a resurgence in the market for patents, in people who transfer license and, yes, assert their patents once again. And so historically, the cycle turns over once again to smaller companies inventing. We're past the days of the mid-20th century vast, industrial concerns that were intertwined with big government and big business, and we've got disruptive innovation going on. And that disruptive innovation, those small innovators need to be able to depend on their patents, to value them, and they need to be able to assert them to keep the market honest. When the little guy goes to the big guy, the little guy with a patent, the little guy needs the big guy to have a reason to actually license it, buy it, invest in his company, purchase her product instead of copying it. And when you make the patent less easy to assert, you make it less easy for the little guy to do that. And so the more expensive it is to litigate, the more likely the big guy knows they can sit back and copy. And big companies do this. They do this strategy. I had clients who did that, who engaged in this strategy. Let's see if they sue. And furthermore, even the so-called patent trolls, which are ill-defined, they're most easily defined as somebody who's suing me. That's always what a patent troll is. But even those entities play a really important role in the ecosystem, in the patent ecosystem, because they are, in some cases, the small inventors, the small company individual inventors' last resort for doing something with their patent. You start a company, you try to make a go of it, for example, or you try to get a big company to buy your technology, and you fail. Well, where else can you go? Your last resort is a licensing company. And going back to the Lamoureux and Sokoloff paper, this happened similarly in the 19th century. Another thing that third parties who buy patents offer is they often know who to go to license the invention to. They have better information about markets, and they have capabilities to sue if they need to sue. And so they're more credible when they try to get people to license. And here's the last irony. Here's one last irony about some of the current proposals, is when you make it more expensive to assert a patent, who's more likely to assert a patent? The individual inventor or a so-called patent troll, non-practicing entity who has resources, who can buy the patent, who specializes in litigation, who can bear that risk, say, of fee shifting? That is who is more likely to be able to assert the patent. So the little guy is even more likely under these proposals, if they pass, the little guy's even more likely to sell the patent troll. So maybe we intend with this legislation to cut back on licensing company lawsuits. It might succeed to some degree. That might be one of the effects, to make it more costly. But on the other hand, you have a countervailing effect that may cancel that effect out of making it harder for little guys to assert their patents themselves, and thus more likely to sell them to companies that specialize in asserting patents who have the resources to do so. So what effect we finally get out of this legislation is rather ambiguous. And I'll end there because I think the questions and answers will be quite interesting. Thank you.
Thank you, Mark. We'll call that the academic filibuster. We had two entrepreneurs that come up and they just want to sit back down and keep their heads down. But we want to hear more from Mark in a second. Valerie missed one story of hers that Mark alluded to, and that's where, and it's a company that Valerie was an A-round investor in that most of you might have one of their products in your pocket right now. But they sold their IP, and that's where what I see when I read a bunch of the discussion drafts and a lot of the legislation that's out there, and they miss it's the troll versus anti-troll, but they forget about the small business side and the fact that IP is important to them. Can you tell the?
Yeah, sure. Most people think that these big companies are the greatest inventors of the world. And the reality is, as a small investor, we invest in these small companies that oftentimes will just build a small component of which fits into what the big guys are doing. So, an example of what The example what Charlie is referring to is a company that we had pulled together, our investment group, a company called Fingerworks. Fingerworks was touchpad technology. This was back in 2004. And initially, the founder wanted to create something that would help people reduce repetitive motion disorder. And wanted to sell it to insurance companies so that you don't have to be tapping on the mouse. Well, one of our investors came from, had left from a very large technology company, identified the technology, recognized where it could go, and we put a little less than, I think it was about $850,000 in collectively, and less than a year later, we sold it to Apple, and essentially it is the touchpad that enables you to make your picture smaller or bigger in your iPhone. That's one component, okay? Now, could we have created a company that would have competed with Apple? Heck no. Was it cheaper for Apple in the long run to actually buy the technology from us? Yes. So here's winners all around. And now the one thing that most people don't understand is that when we sell this technology to somebody like an Intel or a Google, oftentimes we as investors are prohibited from actually talking about that until a certain period of time has passed. So Apple can go around and say, yeah, we're the greatest inventors of the world. I have the prototype. They aren't. I mean, they are the greatest aggregators of technology. So that sort of technology enables the little guy to invent these little things because, frankly, we're on the ground. We're on the ground. We see things at a micro level to fix things, whereas a lot of these bigger companies are not. And in many respects, technology, patents, and any kind of intellectual property gives me something to invest in because I know I now have a physical property. And as was alluded to earlier, is that if the company is not able to succeed, I have a garage sale, right? What do I have? I've got office furniture and now some technology which could potentially be useful to somebody else.
This whole argument about the patent stuff is interesting. If you look at this from a meta level, there are natural ecosystems in business that sort of get generated. Back in the internet boom world, for example, a friend of mine was very high up at Cisco Systems, right? And Cisco, you could map out their spending in R&D was going down, 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 down. And their spending in buying companies was going up, 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 up. And I asked him at dinner one night, I said, so you guys doing any R&D at all? And he's like, not much. And I said, why? He said, look, here's the ecosystem right now. The VC are pouring money into anything that moves. That's real money. We're a company soaring, our price, our stock value, our price per share is through the roof. And when we buy companies, we mainly buy them for stock. So we've got a currency.
You might want to add that the reason why the stock prices were going through the roof is because they weren't spending money on R&D.
Well, that's a big, that is true. It's true. I mean, they're in the middle of the boom, But, when you look at this and you go, listen, there's an ecosystem here. A lot of times what happens is someone in one end of the ecosystem, one piece of the ecosystem decides to get greedy and make a grab for another chunk of the ecosystem. And that throws things out of balance, completely out of whack. Because there's actually a natural reason why everything flows like this. There's a natural reason why little guys invent. And they invent because they're broke. They invent because that's the only game they can play. They invent because they don't have to invent by committee. They invent because they have a great idea. And if they told it to anybody, they'd think they were nuts. So they just go off and they do it, okay? That cannot occur in a big company. I'm not saying it's unlikely to occur in a big company. I'm saying, having been through all of this stuff, it never occurs in a big company. When you walk into a big lab that produces 100, 200 patents a year, they're actually not very good patents. They're usually crap patents, as we call them. It's a technical term. And, they're usually, you're like, great, okay, look at this patent. You read through it and you're like, I'll get coffee, I'll read that again. So you get coffee and you read through it again, and then you're like, scotch, and I'll read through it again. And eventually, you do manage to put your head into a state where you can read this patent and actually say, I guess they're innovating and creating some sort of value in this really narrow little corner over here. And then you're like, why in the world would somebody chuck $50,000 at, oh, wait a minute, they have internal lawyers. Oh, wait a minute, the lawyers need to justify their jobs. Oh, wait a minute, the scientists need to justify their jobs, or whatever. And then all of a sudden you realize what you're really seeing. It's a bunch of motion and noise and flame and smoke about nothing. These guys don't really invent like that. But by changing the law to favor those guys, you're going to kill off the little guy. And the little guy's where all the innovation happens. And you're just going to kill them. They're, oh, well, we're going to make it easier we'll make it, again, first to file, not first to invent. Excellent, great. But you know what? I know guys who invent cool things, and they've never seen $20,000 in one place at one time in their lives, okay? So I don't know how the hell they're going to show up at the Patent and Trademark Office and actually do this. Oh, I know how they're going to do it. They're going to be one of your patent trolls, right? They're going to actually have to go to somebody and say, will you finance me getting the patent? Well, Valerie over there doesn't want to finance getting the patent. Valerie wants you to get the patent before she finances. Basically, and I know that no one here is deliberately doing it, but by going in and mucking with the ecosystem, you're going to kill off all the little fish. And the big fish are all like, we don't need the little fish anyway. Well, guess what? They're actually wrong about that, but it's going to take 10 years, 20 years for them to find out. So.
Mark had a really good point when he talked about, in fact, I like the term you said, commit further reform. I think, what went into my mind is, commit further assault on innovation. And as Doug said, it's going to take a good 10 years. I started a healthcare venture fund, and using the analogy of doctors, and I'm sure you've all been to the doctor, and whenever they change some medication, they don't do all the medication at once. And while they're in the process of seeing how the medication change has affected you, they're thinking about what's next. I think looking at what has been done so massively with the last set of reforms, it's unfathomable to think that we haven't even let the dust settle to understand how this is going to affect the ecosystem before we are now going to layer something on top. A doctor would never do that by changing one medication or by changing 6 medications at the same time and then trying to figure out what's wrong. The same thing is with technology and with your computer. You change 5 different settings at once. You'll never really understand what is going to be affecting and really messing up your computer. So I think, as Mark said, we've got to kind of take a step back, take a look at, what is happening. And I think that, according to Gary Lauder, we're already seeing more litigation happening as a result of this last year. We haven't even seen case study come out or the effects of what this last legislation has done. Now, I, as an investor, that's really problematic for me, because if I invest in a company and now all of a sudden the property which I think I've invested in now is totally wiped out from under my feet, I have nothing to invest in. Think of intellectual property as collateral, as an investor comes in. And that, I think, is really, really important and needs to be impressed upon above anything else, is that, do no harm. And I think we haven't even figured out what harm that this legislation has done yet. So at least let's figure that out first before we start layering more things on top.
Mark, have we seen a start of a changer in the markets or anything from AIA?
We're seeing initially, yes, some uncertainty. It's hard to say, and that's part of the point, is we don't know yet. Things are still working their way through. It's a 2-year-old piece of legislation, really less than 2 years old, and it only part of it's relatively recently come into effect, and we don't know yet. The other point I would make about adding on to something Valerie said just now about layering on reforms, some of the less controversial reforms are perhaps some of the less necessary ones that deal with limits on discovery and litigation, pleading and case management. Those are things the courts can do. And that brings me to a broader point is let's not forget there are other institutions in the system. We don't have to solve everything with legislation. First of all, patents are property rights, which means that they can be asserted or not asserted by a private party. A private party can decide to cooperate with others in patent pools, in standard-setting organizations, through lots of forms of private ordering. People work out arrangements over time and figure out how to assert their property rights. You don't need to tell them how to do it. They can often address problems in the system themselves. And then you have another actor, the courts. When it comes to things like discovery abuses, pleading and case management, judges do have the inherent power to deal with these things. And indeed, Judge Rader, the Chief Judge of the Federal Circuit, has recently signaled, or more than just signaled, he said that courts should do more, and he wants courts to play a stronger role in making sure in reducing litigation abuse. So those are other reforms that happen without legislation that we should allow some breathing space for.
I'm curious if you could, kind of in a nutshell, discuss what are the implications if you add a prohibition against or limitations on transferring patents to people that don't manufacture things. How does that affect investment, and how does it affect liquidity that comes about as a result of investment, and ultimately affecting innovation?
Be a little bit more specific when you say.
Well, I think that you've done a good job of explaining why patents are important to you as an investor. What I'm curious about is a more specific question. And the more specific question is, if you had a change in the law that put limits on the ability of a venture to sell his patent or license his patent to a non-producing type of an entity, how does that adversely affect, first of all, your ability to and desire to invest in the company? And secondly, does it have an effect on the overall liquidity in the system that ultimately affects the inventor and the incentives for innovation?
Yes. So essentially what you're doing is you're now limiting the market. When you go to sell something, anything to anybody, I kind of don't care what they do with it. If they want to buy it, they want to buy it. You now will totally wipe out one segment of a market that I can sell that widget to. I mean, it's almost that simple. So and if you start saying now, if you put the restrictions on the person who buys it and said, okay, you I don't know, you can buy a technology from somebody, but then you can't, if you don't use it, you can't sue somebody else with it. Well, if I'm the buyer of that technology, I don't know whether I'm going to use it or not. Sometimes it may be part of that inventive process where I buy a piece of technology, I embed it in what I'm trying to put together, and all of a sudden I say, you know what, that's not going to work. I need a different solution. So now I just bought this patent that could be more valuable to somebody else. If I can't resell it to somebody, it's just like ideas when you're brainstorming, right? I may not or may not be able to do something with that technology, but somebody else may. So when you start putting limitations on that, you're actually quashing innovation.
And I think you can look to a first principle and just say, if I have something and I can sell it to anyone, it's worth X. If I have something and it's limited as to whom I can sell it to, it's worth less than X. That's just straight up. If I have a piece of land and I can do anything I want with it, great. Now let's just say that somebody says, well, you bought the land, you own the land, but we're going to give a visual covenant to all the people who can see your land and say, you can't do anything on that land that would upset anybody visually, okay? Who's writing me the check for that? Okay, you've just put a covenant on my land. Who is writing me the check for the fact that I can no longer now do anything I want with the land? Now I can only build something on the land as long as I get the approval of the 12 different people who can see the land and approve that it does not offend them. okay? And that guy doesn't like Italian, or this guy doesn't like Baroque, and this guy doesn't like modernist, okay? So what, I have to build a country home, I guess, right? Who the hell is writing me the check to compensate me for that? Because that used to be a $2 million piece of land. And it's not a $2 million piece of land now with all these covenants slapped down on it. Now that is just the way it is. So if you don't, if people can't believe in that, then you don't understand capitalism.
Well, yeah, I mean, and even one step further, I would actually even take it that, okay, you're allowed to buy that piece of property, but you're not allowed to resell it. Oh my gosh, why would I buy something?
Yeah, well, that would, I mean, if I want to talk to the Nature Conservancy, I can go do that deal. But, you know, I'm not donating land. I mean, that would be my other thing, which would be to say, okay, if no one wants me to use this land for an ugly thing, then all you boys, here's the price tag I want for the land. Everybody pitch in, throw your money together and buy it out from under me and preserve that right. No, they won't hear that they're willing to do that. But they're willing to go to the government to try to get the government to enforce fetters on me as to what I can do with my land. Patents are land. And you know what? You try and see them that way.
So to say a couple quick things, it's fundamental to both the moral and economic case for property that you can freely alienate it. If you don't have that, you don't have property, and you know, for hundreds, thousands of years, that's been what property is about, right? That is part of both the moral case and economic case for property, is it empowers people by allowing them to freely alienate it. You take away that freedom, and you take away some of their own individual liberty and ability to realize their aspirations. And just to even put a simple spin on the proposal, to take the land analogy further, it's like saying you couldn't sell your house to somebody who was going to choose to rent it rather than live in it, or you couldn't sell your house to somebody who was going to redevelop it, knock it down and redevelop it. And we know what I think all of us can easily imagine what that would do to the value of our property.
So let me take it even one step further. Now, if you came into work this morning and your boss, House Senate member, said to you, oh, and by the way, your idea is worth nothing. Okay? I don't care whether you write me a report, I don't care whether you draft legislation, it's worth nothing. You can only, limit that to go only to the committee, or, I mean, how would that motivate you to start coming up with ideas on how to fix things? It wouldn't be very much, would it?
That was the economist in me was changing the, if we lower the value of IP, you then lower the incentive for people to innovate, and therefore you lower economic growth, which is why we are Entrepreneurs for Growth and why we're here to talk about the value of IP. Let's look for, is there any other questions?
Doug, I really enjoyed your colorful description of what you called crap patents. And I'm wondering if...
It is a technical term.
I have heard that in the law.
Use it anywhere in the industry and you will completely know what you're talking about.
Preciseness is the essence of the law. So I'm wondering if you see this as an issue. Do you think that the fact that companies, and all sorts of entities, are able to get these sorts of things, does that mean that there's an issue, or was it a need for your business as well? Do you do pre-clearance searches? Do you worry about entering into patent thickets when you walk into new business opportunities?
I don't worry about what anyone else does as long as they allow me to do what I want to do. So if IBM wants to build a facility, or Pfizer, let's just pick a few people who might have had something to do with that bill. If they want to build a big facility and staff it up with 1 million people and crank patents till the cows come home, I do not care. If they want to come in here and lean on their elected officials to change the rules to benefit them over me being able to do my patents, then I do care. So let them do whatever they want to do, crank up whatever they want to crank up, but it's not enough apparently that I'm in my garage working and trying to patent something versus, IBM TJ Watson, where they're employing, 9,000 people to crank stuff. You know, it's not enough that they don't already have enough of an advantage that to them, the filing fee, they have internal lawyers to do their RPAs. They don't need to hire a lawyer to do their RPAs.
And
They're
they get bulk discounts.
They're already paying them. They get bulk discounts, right? They ship them in by the truckload. You know, they employ people who used to work there constantly to be able to get the, you know, to the most subtle nuance, whereas I'm out finding a individual patent practitioner of some sort, a scrivener or a lawyer or whatever. I'm finding an individual who may or may not have the advantages of the fact that, you know, he has all that legal power on tap. But that's okay. I don't care. That's the market. And you know what? I'm not asking for anybody to intervene on my behalf, but what I want to do is not have them intervening against my behalf. And that is what the AIA was basically let's go stack the deck and rig this thing so that large guys who crank tons of patents won't be inconvenienced by the fact that an individual might actually show up with something. Yes, individuals are a pain in the butt. We get that. But the thing is, they are the most inventive of all of the parties in the equation. So if you go stomp them out, yes, you'll have less variance, you'll have less pain in the butt, but you'll also crush all of the innovation out of the system. That's what I'm trying to point out. I'm not trying to tell anybody else not to do what they do, but I don't want them to go rig the legal system so they have all the advantages.
I think that there's a second part to this, and I've talked about it with Mark before a little bit, and he alluded to it. This is crap patents. There's a system to take care of those, and it already in place, and it doesn't take congressional action, right?
Well, right. You litigate, right? I mean, first of all, look, we've seen historically when you have a new field of technology, there's some uncertainty. And the patent, there's more patent litigation, and there's more uncertainty as to what's covered. And as time goes on, and the patent office becomes more familiar with the patents, and the market becomes more familiar with them, and patent attorneys become more familiar with that field of technology, you have less litigation, less issues. So that's one thing, that this is just, you're always going to have some of this in the system when you have a new disruptive technology. Second thing is that, yes, litigation resolves many of these problems. I was talking with Charlie about Thomas Edison. In fact, just to go back to the Edison example, not only did Edison assert patents and sell patents, he was on the receiving end of patent litigation. One of the most famous cases was the incandescent lamp patent case against him, where the inventors had specified a carbon-based filament, but hadn't specified which carbon fibrous material would actually glow. And Edison did the work, looking at thousands of kinds of fiber, determining which would work. And that patent was invalidated because it had failed to actually enable the invention. So, even Edison, who asserted patents, was also on the receiving end of a crap patent, a broad, vague patent, and the system took care of it. And that's, just a historical example. Of course, this happens every day in the courts. Patents are invalidated. And so we have a system for dealing with that.
Well, we want to thank you all for coming. Doug's got to run out of here today, but if you have any questions for Doug, you can share them with me, and I'll pass them on. Valerie and Mark will be around here for a couple of minutes. Thank you all again.